The next matter is Rashina Gussom versus Maurice Teagle. Representing Rashina Gussom is Robert P. Maisel, and representing Maurice Teagle is Joseph B. Mayers.
Good afternoon. In this civil case, the plaintiff commenced an action in which he claimed damages arising from a motor vehicle incident. However, the defendant could not be located and notified within the statute of limitations period, and the case was dismissed. We were asked to determine whether the case should have been allowed to proceed on the ground that the plaintiff's efforts to notify the defendant were sufficient. Hearing Brian, but I don't hear him.
Attorney Maisel, can you see and hear everyone?
I can see and hear everyone. There is some background noise just from shuffling of papers, and I was having a little trouble hearing Chief Justice, but I can hear, yes.
Would you like me to restate the case briefly?
No, Your Honor. I heard that, and it was correct. Yes, Your Honor.
With that, you can open your argument.
Thank you. May it please the court, this matter comes before you as a result of the Superior Court's divergence from this court's precedent, specifically on the issue of service of process as it relates to what constitutes a good faith, timely effort to serve a complaint. Though no bright line test exists as to what precisely constitutes good faith effort to effectuate service, through Lamp and its prodigy, Farnici and McCreesh, this court has established precedent that currently governs what conduct constitutes a good faith effort relating to the service of process. Inaction does not equate to intent. In several recent decisions, including this matter, the Superior Court has worked to undermine the spirit and purpose of this court's precedent by holding that non-prejudicial missteps amount to intentional conduct to stall the judicial machinery, or seeking to create some bright line test. Some panels of the Superior Court erroneously rely upon intermediate appellate court decisions which hold that unintentional conduct that delays a defendant's notice of a claim constitutes a lack of good faith effort to effectuate service. In those matters like this case, the Superior Court improperly undermines the established precedent. The Lamp line of cases clearly stands for the proposition that mistake or unintentional conduct does not rise to a level that intends to stall the judicial machinery. Here, appellant made several good faith efforts to serve the appellee and in no way acted in any manner that intended to stall the judicial machinery or deny notice of the claim. Though the Superior Court has inconsistently applied this court's standard, Lamp, Farnici, and McCreesh remain precedential and clearly hold that there's no bright line test that exists for a good faith effort to effectuate service. Rather, simply a party must act in good faith not to intend to stall judicial machinery. Pursuant to Lamp and its progeny, the appellant respectfully requests that this honorable court find that the appellant made a good faith effort to serve in a timely fashion and remand this matter.
Counsel, Justice Baer, I wrote McCreesh versus Philadelphia on the court's behalf. And in preparing for this case, I'm not convinced that I did not make a mistake, which I may need to write to correct. It seems to me that if there's no question under Lamp and the progeny, that it's your burden to prove that whatever the standard is, that there was no intent or that there was no delay or the like. Would you agree with that?
Yes.
Okay. It seems to me to be somewhat counterintuitive to have you proving a negative, that you're proving there was no intent to delay. I think more typically, if that was the criteria, it would fall upon the defendants to prove that you intended to delay or the like. Number one. Number two, and number two, it seems to me that McCreesh is arguably inconsistent with LAMP. As I read LAMP, the criteria should be, did you diligently attempt to serve? And if you diligently attempt to serve, then maybe the implicit corollary is there's no intent to delay. But in any event, I think that should be the test. So quickly, does it make sense to you that you have the burden of proving the negative, that there was no intent to delay? And secondly, should the criteria be diligent attempt to serve?
Justice, to respond to your first part of your question, it should be that the appellee should have the burden of proof to show that we did not make a diligent attempt. Nevertheless, in our motion for reconsideration and our brief to the Superior Court, we set forth all of the steps that we took in our attempts to not only make service, but also to find the original defendant, Maurice Teagle, whose whereabouts were unknown to us until service was actually effectuated. It may be important to point out in that part of my answer to you that in the facts of the underlying matter are extremely important in that counsel had entered his appearance for Mr. Teagle prior to our making service. Therefore, as part of the line of cases under LAMP and its progeny, there was no lack of notice provided to the defendants. The defendant knew about this case clearly as his counsel had entered his appearance.
Had he entered his, let me just make sure we get this clear. Was his appearance entered before or after the statute of limitations ran?
The statute of limitations would have ran on July 25th of 2018. The appearance was August 13th. So it was right after the statute of limitations.
And of course, it may be tactical that he awaited that. So I mean, we have to look at the record. That
may be. I cannot read into the mind's eye of what counsel was thinking at that time.
Mm-hmm.
That's correct. Nevertheless, the entry of appearance came. We continued to make diligent efforts to locate Mr. Teagle, and then after diligent efforts were made to locate Mr. Teagle, service was attempted in Virginia. It came back to us, and then thereafter, then counsel goes and files preliminary objections, and after the preliminary objections are filed, we actually make service.
Counsel, go ahead and finish your answer. I thought you were done.
No, that was actually, I was just trying to respond to part one. Nevertheless, I do believe that it is actually up to the appellee to prove that we did not make a diligent attempt.
Do you agree that under LAMP, which I think is the bellwether case here, that you have an affirmative duty to prove that you diligently attempted service? Not getting into whether you met that burden or not. I appreciate the facts you just provided us. Is that the starting point for this case, that it's your burden as plaintiff in serving to diligently attempt service?
Simple answer, yes, Your Honor.
Okay, thank you so much.
You had part two of a question, and I tried, I tried to jot down notes, but I missed part two. That I need to respond to. I
think you've probably answered it. What I had asked you, secondly, is whether or not your burden, which you've confirmed for me, to diligently serve, is inconsistent with imposing a burden of intentional misconduct. Now, if you want to elaborate, you've already said, A, that it's your burden to diligently prove that you attempted to serve, but it's their burden to show that you intentionally tried to delay the action. I'm not sure how those two cross burdens of persuasion work, if you want to elaborate, but again, I'll go home and figure it out.
It's very tough because I don't think that there is a exact bright line test. And when we look at the line of cases, specifically Lamp and McCreesh, what we're really looking at is the totality of circumstances. And was there any kind of intent on our purpose, or on the plaintiff's purpose initially, to stall the judicial machinery? When we look at Lamp, there was a clear intent of that counsel to not serve the complaint. That's not what occurred here under Gussom. And when we look at McCreesh, I think that, Your Honor, that I think that the purpose of ultimately the entire case was that there is no bright line test, and that we're looking to see, as long as you didn't stall the judicial machinery, you were acting properly under the rules. Because Rule 401 does not state that you have to continuously reinstate. It just says that original service of process needs to be made within 30 days after the issuance of the writ or filing of the complaint, which is precisely what occurred in the matter before Your Honors. Therefore, I believe that it's our position that because there's no bright line test, so long as the plaintiff in this case was taking steps to move the ball forward, so to speak, that they were acting in good faith and not intending to stall the judicial machinery.
Counsel, it's Justice Donahue. Can I follow up on Justice Bear's line of thinking? This diligent attempt to effectuate service, is that within 30 days of the issuance of the precipice or the complaint? Is that what you're contemplating here? I'm trying to probe this because part of the problem with our case law is that it's somewhat imprecise. So let me ask you this question. Let's say that you commence an action, and on the 20th day, you get 30 days to serve, correct? Okay.
Correct.
On the 20th day, you're a sole practitioner, you have a heart attack. And as a result of that, there's no attempt to effectuate service within that 30-day period. I would say under Lamp, that is there's no intent there to stall the judicial machinery. It was an unforeseen circumstance that occurred, or there could be negligent circumstances that occur so that there's no attempt at service. So I'm just not certain that proof that there was no attempt of service during that 30-day period gets you where you need to go under Lamp. I still think you have to establish intent, or the defendant has to establish intent to stall. Am I right? I mean, am I thinking right on this, or am I missing something?
I couldn't have said it better myself. I agree with you 100%.
Okay, so let me see if, and I thought McCreesh was a very clear statement of what the law is, which is why I'm perplexed as to why we continue to see these cases. You either show an intent to stall the judicial machinery or prejudice to the defendant. Am I correct?
Yes, you're correct.
It says, right? I mean, one of the friends of the court suggested that we should send this to our Civil Rules Committee in order to get some clarity on this. To be honest with you, unless we write a rule that says follow McCreesh, there are two ways. I'm a little bit. And correct me if I'm wrong. I mean, because this law has been going on for a long time, but it seems to me that Farinacci is where we zagged off course a little bit here.
A little bit.
Yeah, more than a little bit, because it really, based upon an abusive discretion standard, essentially blessed this notion that somehow negligence fits into this equation of whether or not you're complying with LAMP. I mean, if there's a deviation from the clear statements of LAMP and then McCreesh, with all due deference to Justice Baer, which I think is perfectly clear, it's Farinacci that created a little zigzag off course. Do you agree with that?
I would agree with that, but I also would add that McCreesh is really the current statement.
No question. But the Superior Court somehow keeps going back and grasping on that 1986 statement that was really done on an abusive discretion standard versus a true statement of what the law is. But if we just follow McCreesh, do we have a problem here?
In the matter before your court, before your honors in Gussom,
or any case, or any case, but take your case.
Taking my case and applying the facts of my case to McCreesh, I believe that this case should be sent back because I think that there's been first of all, you can't show that there's an intent to stall the machinery, and second of all, there's no prejudice here as based upon the facts is when I was addressing Justice Baer, that counsel for the defendant chose to enter their appearance and also file preliminary objections on the issue in part of service. So there's no prejudice here on the defendant, and there's clearly no intent. I think going forward from this point, I would respectfully look for some guidance that says that there is no bright line test of the restatement every 30 days, and that the holding is very clear that it is all about the intent of the party to stall the judicial machinery.
Counsel, this is Justice Doherty. With regard to Farinacci, the case requires a judicial determination of good faith. That would have been effectuated by a response to the preliminary objections challenging service. Yet your client refused or failed to respond. Why do you benefit from your failure to respond for a court to make a determination whether, in fact, there was good faith?
Well, in response to the preliminary objection issue, if we look directly at the order that was entered by Judge Patrick in the Common Pleas Court, Judge Patrick denies the preliminary objection based upon our lack of good faith effort to make service, and in doing so, she reviews the docket as filed. So her decision also, when you look at her order, she relies heavily upon the Englert and Devine line of cases, not the cases of Lamp and its progeny. So from our position, first and foremost, it was an inadvertent mistake that should not be held to it was an inadvertent mistake by counsel, so that should not be held to penalize the plaintiff on the issue of service. And I think
how do you test that then? In other words, they filed preliminary objections contesting the service issue, and you contest that by responding to the preliminary objections. But you didn't even do that.
Well,
how would a defendant test this?
Well, we filed a motion for reconsideration.
Well, I understand that, but I'm probing If there's an issue over service, how do you test it? Do you file a motion to dismiss the complaint for lack of service? Or do you file preliminary objections? But in either case, you can't just ignore these court orders.
It was.
I thought not to interrupt you, but I thought the judge's order said complaint dismissed with prejudice or failure to make good faith efforts at service. So apparently there was something in front of that judge, Judge Patrick.
Judge Patrick, when her order was following what was filed by the defendants, and at that time, and also what was fought in their preliminary objections, and based upon the docket as it reflected at that time. Unfortunately, when the preliminary objections were entered, the docketing of the ultimate service, we had made service on September 29th, but unfortunately that service did not get docketed until October 10th. The order granting the preliminary objections was entered on October 3rd. That's where, in our motion for reconsideration, we filed we outlined that timeline and to show that in fact we had made service, that there was no service issue at that point, and had we responded to the preliminary objections, this is what we would have said. The motion, unfortunately, for reconsideration was denied, which ultimately led us to the Superior Court level. And if
Well,
we
I
look
don't think we want to hear what you would have said to something you didn't respond to.
I'm sorry, I didn't hear you.
Why would we court want to hear what you would have said in something you didn't even respond to? That's not the way the law works.
Well, we also set forth the issues that we didn't respond. It was an inadvertent mistake. It was not something that we were simply ignoring or attempting to overtly not answer.
Counsel, it's Justice Baer again, because I thought you had answered, and then in your colloquy with Justice Donahue, you confused me a little bit. I thought you said to me that it was your burden to show a diligent effort to serve. My question to you is, and you know, the converse would be Macreece, that there's no prejudice and there's no intentional delay. So again, apropos a little bit of what the Chief Justice asked, you assume hypothetically, and it's not your facts, and I know that, but I'm looking for a test. Hypothetically, that a plaintiff's counsel files a complaint and then takes a around the world cruise, forgetting about the complaint, comes back a year later and says, whoops, I never served that complaint. Fortunately for me, there's no prejudice to the defense. Witnesses are there, facts are still there. And I certainly was simply inadvertent or negligent, as I forgot about this before I take a cruise. Is the plaintiff permitted to go forward, or is the plaintiff barred under those facts?
Under those facts, I would say the plaintiff is permitted to go forward.
Okay, fair enough. So you're looking for intentional delay or prejudice as the criteria?
Yes.
Okay, thank you.
Thank you.
Thank you. Okay, thank you. We'll hear from Mr. Maris.
Thank you, Your Honors. Procedurally, should I mute myself now?
Yes.
Thank you.
Yeah.
Good afternoon again, Chief Justice Saylor and Associate Justices. May it please the Court. Whether you apply a mechanical approach or you apply a flexible approach to the facts of this case, I do not believe there's any doubt that the Superior Court decision should be affirmed, as the appellant failed to demonstrate any good faith attempt to effect service on the appellee. Between their first attempt at service, which occurred on May 4th, and their reinstating the complaint on August 22nd, 2018, there was a period of delay of 110 days. And in that time frame, the statute of limitations had run without service and without actual notice. Despite the fact that the appellant had the burden of proof at the trial court level once the preliminary objections were filed, the appellant never responded to those preliminary objections. and as if we have addressed in our brief, and as the amicus brief provided, we believe that that was a waiver of the argument, and we do not believe that the motion for reconsideration preserved these issues on appeal. However, I'll rely on our briefs with regard to those arguments. However, even considering the motion for reconsideration that was filed by the appellants, there was no good faith effort identified in those 110 days before the statute of limitations expired. There was no freedom of information request. There were no internet searches. There were no attempts to locate the family or neighbors or employers. There was no social media investigation. There were no attempts to hire a private investigator. And maybe most significantly, under Pennsylvania Rule of Civil Procedure 430, there was no attempt to file a motion for a special order or for alternative service. And what I think is instructive for this court is that while the appellant argues that there's no definition for what constitutes a good faith basis, when one examines the notes to Pennsylvania Rule of Civil Procedure 430, there's an illustration of what constitutes good faith.
Can I ask in that regard, Mr. Myers, pardon me for interrupting you, sir. Did your client refuse the certified mail in Virginia?
No, not to my knowledge. To my knowledge, that there was no service in Virginia because he did not live at that address in Virginia.
And did your client get notice from his insurance carrier of the service?
Well, I don't believe there's any record facts to that effect, Justice Weck, but my understanding is that when counsel filed their entry of appearance on August 13th, which was beyond the statute of limitations, it was based on appellant counsel advising the insurance company for the defendant of the lawsuit. And at that point, counsel entered their appearance, which isn't, as you know, a waiver of service, but to simply make sure that they got notices of future docket events.
Just one more question. One more question, discreetly. Is the burden in your judgment? Does the law put the burden on the plaintiff to establish good faith attempt, or is the burden on the defendant to establish an absence of good faith on the part of plaintiff?
I believe, Justice Weck, that it's clearly the burden is on the plaintiff, and I think that burden was set forth in Lamp, it was set forth in Farinacci, and I believe set forth by Justice Baer in McCreech. I don't believe that there's any doubt about that as the law stands today, that is the plaintiff's burden of proof.
Counsel Justice Baer, it seems to me that what we have fairly purely are two criteria. That the criteria you assert is that the plaintiff has the burden of proof to demonstrate good faith in its efforts to effectuate service. I think that's a pretty fair approximation of what you said to begin. And conversely, I think that your opposing counsel got around to the idea, when he answered my last hypo especially, but generally, that good faith on plaintiff's attempt should not be the test. The test should be, was there intentional delay rather than negligent delay, and was there any prejudice to the defendant? It seems to me under the test you articulate, you probably prevail, and under the tests that the plaintiff articulates, you may not prevail. Now, I don't know that anybody has explored whether there's prejudice in this case as of yet, but you may not prevail because the argument that the trial court could accept is the one I just made with the Cruz, that the plaintiff's counsel absolutely was negligent, but there was no intent and there's no prejudice, so we prefer to get to the merits, let the case go on. So I think it would be helpful to us if you explained why it's not we should not, and perhaps we're going away from Lamp, but we can do that, it's a 50-year-old case, why we should not explicitly provide that if you have not intentionally delayed and there's been no prejudice at all, that will get to the merits of the case instead of barring you.
It's a good question, Your Honor.
Thank you.
And let me respond to it this way. I think that requiring the standard of intent turns the purpose of the statute of limitations and the rules that exist on service on their ear. For instance, how would it be possible to prove intent? And is the hypothetical that Your Honor proposed, where you file your complaint, sail around the world for a year, the statute expires, and you come back, how does that coincide with the purpose of the statute of limitations, which is to expedite litigation and to discourage delay and the presentation of stale claims, and the strong public policy in favor of a strict application of the statute of limitations? As Your Honor pointed out in McCreesh, it's self-evident that once an action has been commenced, the defendant must be provided with notice of the action in order for the purpose of the statute of limitations to be fulfilled. So hypothetically, under the existing law, with a 2-year statute of limitation, if the appellant in this particular case filed their complaint or their first filing 1 day after the statute of limitations, it's clear that their case would be barred. There's no prejudice standard for that. They missed the statute of limitations. They didn't file in time. Their case would be barred. So if the statute of limitations, as Your Honor pointed out, is not fulfilled until the service or the actual notice to the defendant within the statute of limitations, how is it possible for prejudice to be applicable to that scenario and not the scenario when you file beyond the statute of limitations with your first filing? It seems incongruous to me. And it seems incongruous that a defendant will ever be able to establish intent. How is that possible to be done? And with regard to the prejudice,
that's very easy to be done. In the old cases where somebody would file writ and tell the sheriff not to serve it. There's no problem discerning that. And secondly, as long as you filed within the statute, you've told the statute. Right. You just have to effectuate the tolling by valid service of the writ. So you can protect the statute by filing the precipice for the writ 1 day before the statute expires. So we're talking about what happens after that, obviously. But I guess there's a final policy consideration at play that, I think courts would say that once a plaintiff implicates the judicial process, that plaintiff has an on-shifting burden to keep moving that case forward through the system and not be dilatory, because it's the plaintiff that's implicated the resources of our judicial system. And so, to use Justice Spear's hypothetical, if you file a complaint, you protect the statute, and you leave for a year and don't do anything to serve it, service, I would tend to agree with your position and not that of the appellee.
And if I may add one other point on the issue of prejudice, as courts have held, including the Kalura versus People's Neighborhood Bank case, that prejudice is inferred where the defendant has not been provided with actual notice until after the statute of limitations, because the whole purpose of the statute of limitations is to provide that appropriate notice to the defendant. And once it's not accomplished, it's presumed that there's prejudice. And I would suggest, even as a practical matter, the defendant files preliminary objections. How is it then that the defendant has at its disposal the method to determine that prejudice has occurred? In many cases where a complaint is filed, it's a first notice to a defendant. Defendant doesn't know where the witnesses are. The defendant doesn't know if the witnesses' memories have faded. The defendants don't know if evidence has disappeared. The defendant doesn't know if it's a car accident case, where the vehicles are. So by requiring this idea of prejudice, the court would be mandating that the defendant basically go through the entire case of discovery before it could determine whether prejudice actually occurred. And I would submit to your honors that that's contrary to the purpose of the statute of limitations, and it's contrary to our rules, both the rules on the statute of limitation and our rules on service.
Counsel, this is Justice Donahue. The situation, and I'm really, empathetic with your position, but the defendant may not know where the motor vehicle currently is the day before the statute of limitations runs. So some of this really is a moving target. And I'm just, could you articulate what you believe the rule should be in order to support your position, whatever that is that you're taking? What should the rule be?
Well, I think, let me say this. I think that whether this court follows the Lamp, Farinacci cases, or it follows McCreesh, I don't think that the outcome of this case is any different. McCreesh set up a situation where if there was actual notice to a defendant within the statute of limitations, and or there was no prejudice, then in that particular case it wouldn't support dismissal. Those facts aren't present here. But to answer your question directly, obviously we want a fair standard both for plaintiffs and defendants. We want a standard where the court gives deference to the purpose of the statute of limitations, and it encourages a diligent prosecution of claims and protects a defendant against stale claims. And I think that the Lamp and Farinacci cases allow a safe harbor to those attorneys who make good faith efforts at actual notice, but not if the actions, whether they're intentional or unintentional, fail to provide that actual notice. And I think that, as I was saying before with regard to Pennsylvania Rule 430, which provides the illustration of those items which constitute a good faith basis, that a plaintiff will have no problem if in this particular case, in response to the preliminary objections that the appellant submitted to the court, internet searches, freedom of information requests, attempts to do social media searches, all these various things. And then if those things turned out not to be successful, to apply to the court for a special order for alternative service, I would suggest that service would be accomplished, and that would be a fair result. And I think the flip side of that, Justice Donahue, is that when there are no attempts to do that, there has been no good faith effort, that the defendant shouldn't be penalized by having to defend a cause of action to which they have no actual notice of before the statute of limitations runs.
So you would not, you're somehow distinguishing McCreesh from Lamb. Why do you think McCreesh is different?
I don't think I am. I think even Justice Baer, and Justice Baer could tell me if I'm incorrect, but I think even Justice Baer, when he spoke of Lamp in McCreesh, was not looking at an intent-based methodology, but yet a good faith methodology. And I think that good faith methodology is what should be the standard, whether it's good faith or it's due diligence or it's reasonable attempts. I think all of those ideas fall in line and are consistent with Rule 430, I think are consistent with Lamp, Farinacci, and McCreesh.
Thank you.
Thank you. Well, you've
Good job.
presented the court with the issue, and we'll take it under advisement. So thanks to both of you.
Thank you, Your Honor. I never thought we would be arguing remotely in front of the Supreme Court, but it's been my pleasure. Thank you.
Well, works fairly well. It's not as ideal as being in the same courtroom, but it's the best we can do under the circumstances. So we appreciate your assistance.
It's like a football game without fans. Take care.
Thank you.
Thank you.
5-minute break, and then we'll conclude the arguments.
The next matter is Chester Water Authority versus the Pennsylvania Department of Community and Economic Development. Representing the Water Authority is Mr. Kevin Dooley Kent. Representing the department is Mr. Justin A. Zimmerman.
Good afternoon. This case involves a provision of the Pennsylvania Right to Know law, which exempts from disclosure information related to an agency's internal deliberations. The primary issue is whether communications between an agency and subcontractors hired by the agency's contractor are exempt from disclosure under the statute. An additional issue concerns whether exceptions to the mootness doctrine apply with regard to disclosure of certain documents that were initially withheld based on a claim of attorney-client privilege and the work product doctrine. Mr. Kent.
May it please the court, I am Kevin Kent from Conrad O'Brien, and I represent the Chester Water Authority, a large regional water authority serving over 200,000 residents throughout Chester and Delaware counties. CWA is engaged in an existential fight to prevent a hostile takeover of the system and its sale to a private entity after CWA rejected an unsolicited purchase offer in 2017. It is in this context that CWA made right-to-know requests for documents in DCED's possession, including communications among DCED, the Act 47 Recovery Coordinator for the City of Chester, eConsult's financial advisor, Fairmount Capital, and eConsult's law firm, McNeese Wallace. Justice Baer, in yesterday's first argument, asked the appellant what went wrong in the Commonwealth Court and what are you asking this court to do? Well, I will answer that question now in this case. The Commonwealth Court's fundamental error was using policy considerations from a separate statute, namely Act 47, to override the plain language of the pre-decisional deliberative exemption to the right to know law, which is clear and deliberate as to the categories included as internal to the agency, and just as clear in its omission of other categories. The Commonwealth Court legislated its own policy regarding what should be shielded from public view, and by doing so, wrote into the exemption terms that are not there, like contractors, vendors to those contractors, or subcontractors. This court should reverse and hold that the exemption does not extend to third-party, the subcontractors of third-party contractors, to ensure adherence to the plain terms that the General Assembly chose for this very narrow exemption. And with that, I'll stop and ask the court whether it has questions.
Justice Baer, I appreciate the allusion to yesterday. It seems like a lifetime ago. It was noteworthy that the OOR denied your request, because from at least my experience, that happens rarely. They do have a statutory presumption of openness, but they denied it also. If we read your position literally, everything has to be disclosed in these I lost the word, but Act 47 cases. Because the truth is that the Department of Economic Development never acts through its own employees or the like. The way Act 47 is constructed is you appoint an Act 47 coordinator. It hires the expertise it needs. Here, the McNeese Law Firm and the Fairmount Capital Advisors. And that forms the Act 47 team, and it works as proxy, regardless if you call them clients or the like. They act on behalf of the Department of Health. So if we're going to say that when there's communications between the Act 47 coordinator and its really small incumbent team, aren't we subverting, we could argue let the legislature fix it, but aren't we subverting the intent of the legislature to allow Act 47 recoveries to go forward with expertise and consultation among the team?
Your Honor, I don't believe so. And here, I think your question identifies the fundamental problem with the Commonwealth Courts and the OOR's opinions, is you start with the premise of the policies underlying Act 47. That's a separate statute from the right to know law. Here, in terms of interpreting the right to know law, the right to know law is very clear. And the legislature could have written in certain entities that should be subject to this exemption, like Act 47 coordinators or contractors of the department. It didn't. It wrote in certain categories like employees, and that's noteworthy. So Justice, I guess I take issue with the immediate jump, not by you, but by the Commonwealth Court and the OOR to Act 47 as a way of interpreting the right to know law in the first place. And I think that's a big issue in this case, and one of the fundamental errors I think that was made here. So I hope I answered your Honor's question.
Kent,
You did, thank you.
Mr. Kent Tom Saylor, you anchor your central argument in the statutory language, do you not, of the right to know law? And it says it exempts from disclosure the internal pre-decisional deliberations of an agency, its members, employees, or officials. It says nothing about contractors, let alone subcontractors. Is that correct?
I agree, Your Honor.
I mean, you're asking the Commonwealth Court, I mean, unless I'm missing something, we'd have to read words into that statute.
Chief Justice, you are exactly right. That is our argument. You would have to read words into that statute, and we think that would be entirely inappropriate in this context. That's the legislature's job to do. And I would point out, Chief Justice, I think if you look at this court's opinion in Governor versus Donahue in particular, which is a right to know decision, that's exactly what this court suggested not be done by the courts of this Commonwealth, which is read terms into provisions of the right to know law that simply are not there. In that case, it was Section 901 that had to do with receipt by an open records officer of an agency and the time frame that triggered. And the court said, really, the courts need to stick to the plain terms of the right to know law when interpreting it, and rejected policy considerations that in that case were tied directly to the right to know law itself, the statute being interpreted. Here, I think the argument that's being made by DCED goes even further than that and says, look at Act 47 and the policies underlying this separate statute and use it to interpret and insert words like contractor into the right to know law.
Yeah, Justice Fair again. So, and I think you did answer my question and answered it well. But I think what the Commonwealth Court was saying is, I'm not sure they used these words, let's look at legislative intent. And we understand the legislative intent behind Act 47. And the legislature, in passing OOR, could not think of all the various places where the open record or the right to know law was going to intersect with other laws. But if they had thought of it, the legislative intent would be to allow Act 47 to be effective regarding distressed communities, to allow the Act 47 team to work on behalf of the department. Is it outrageous to say that that's legislative intent here?
Your Honor, Justice Baer, I don't think it's outrageous, no, but I think it is contrary to this court's precedent. And what I mean by that is if you look at the Commonwealth Court's opinion, it jumps immediately to legislative intent and the underlying policies without addressing first the question of whether the statute is ambiguous. And this court has been very clear that that needs to be done in the first instance. And frankly, the statute is not ambiguous. And I think part of the issue with jumping to legislative intent without undertaking that analysis in the first instance is that you get into policy debates about what's better or worse for purposes of a particular statute like Act 47. And that, frankly, is a dangerous place to go when the language of the statute being interpreted is already clear. I would also note that Act 47 was amended after the current version of the right to know law was put into place. And there are only very limited instances, 2 in Act 47, that provide for basically non-disclosure of information. And those have to do with personnel records and certain negotiations with creditors. So the legislature had an opportunity to address that either in the right to know law in the first instance or when it amended Act 47, and it didn't.
All right, thank you.
Thank you very much, Mr. Kent. We can turn now to the department.
Records at issue still in this case are internal pre-decisional deliberations between and amongst DCED and the Act 47 team, which are not subject to disclosure under the right to know law. The Act 47 team comprised of the 3 firms, eConsult, Fairmount, and McNeese, Wallace, and Nurek. Act 47 specifically provides that DCED appoint a coordinator to formulate and implement a recovery plan for distressed municipalities. Importantly, the coordinator may be an employee of DCED or a consultant. Here, the Act 47 team jointly responded to a request for proposals to become the coordinator for the city of Chester. The resulting contract specifically provides that Fairmount McNeese will assist eConsult in carrying out the purpose of that contract, the formulation and implementation of a recovery plan, which is an essential government function. Subjecting internal pre-decisional deliberations between DCED and the Act 47 team goes against the public interest and the purpose behind the pre-decisional privilege, to allow an open and free exchange of ideas. The Commonwealth Court's decision below preserves that open exchange of ideas. While the General Assembly enacted the right to know law to further government transparency, it also included an extensive list of exemptions which are also equally important. And if I may direct the court's attention to 506D1, which is analyzed in the dental benefit provider case, that specific section clearly contemplates that records held within a contractor's possession would be exempt under the Act. Thank you.
Well, and furthermore, though, even accepting there's no contractual privity between an agency and a subcontractor, is there? A government agency.
I'm sorry, Judge, I'm not sure I understand the question.
There's no contractual privity between a government agency and a subcontractor.
In this case, I believe there is. The Fairmount and McNeese are specifically outlined in the contract to assist eConsult and the department.
Justice Bear.
Are they contractors or subcontractors in your theory?
In this situation, I'm not sure the distinction would make a difference. I think the 3 parties here had the intent, and the purpose of the contract was to allow the team to coordinate with DCED to help relieve the distress of the city of Chester. To make that work, to make that be possible, it's important that these parties are able to exchange ideas frankly and openly between each other without the fear of disclosure.
Well, but they're ultimately going to lead to a public decision, and I thought that's what the purpose of all these statutes are, that it could be subject to scrutiny and transparency.
Correct, Judge. Once it enters the recovery plan, that becomes open, that is published publicly and open to public comment. What we're talking about is pre-decisional communications before any rights of any parties are attempted to be fixed. What needs to happen for the successful administration of this program is for the parties to be able to speak to each other in a confidential manner. Once a decision has been made, that would inherently no longer be pre-decisional.
Counsel,
What about this
it's,
right to know statute that says covers who's it's only exempt from disclosure if you're the agency, its members, its employees, or officials. Doesn't say anything about contractors, subcontractors, consultants hired by third parties, subcontractors hired by subcontractors.
I agree, Judge, that 708 does not use the word contractor, but 506D implicitly contemplates records held by a contractor could be, quote unquote, exempt under this act. And from that, they did not carve out the internal pre-decisional exception.
Well, you could hide a lot of things in the files of a subcontractor.
If they were pre-decisional deliberations that didn't affect the party's rights, and they were just discussions about proposed courses of action, the policy behind letting those discussions happen outweighs an opposite conclusion.
Somebody had a question. I'm sorry I interrupted them.
no, Chief, you didn't interrupt me. You asked the question I was going to ask. Thank you.
Okay, anything else?
No, Your Honor. Thank you.
Okay, thanks to both counsel. And that concludes the argument list for today.
Good afternoon, judges. Thank you.
Thank you, Your Honors.
I know.